Hey everyone, welcome back to the channel. It's Monday, which means we finally get to see what the Supreme Court decided to do with all those major Second Amendment cases that were conferenced last Friday. If you watched my video last week, you know we had 5 huge cases on the docket dealing with magazine bans, rifle bans, interstate travel, and the fundamental right to acquire firearms. The orders list just dropped this morning at 6:30 a.m. Eastern Time, and unfortunately, we've got some disappointing news mixed with a glimmer of hope. Let's break down exactly what happened. Before we dive in, make sure you hit that subscribe button and turn on notifications because Second Amendment news is developing rapidly right now. We're tracking multiple cases simultaneously, and you don't want to miss any updates. Also, drop a thumbs up on this video to help the algorithm push this content to more people who need to see it. Alright, let's start with the bad news and then work our way to the somewhat hopeful news. 2 of the cases we discussed last week have been officially denied by the Supreme Court. Perez versus Massachusetts, which dealt with interstate travel with firearms, and Perez versus United States, which challenged restrictions on acquiring firearms, are both on this morning's denial list. I'm particularly disappointed about Perez. That case asked an absolutely fundamental question. Does the Second Amendment presumptively protect the right of the people to acquire firearms? Think about how important that question is. You can't exercise your right to keep and bear arms if you can't acquire arms in the first place. The right to acquire is inherent in the right to keep and bear. The Supreme Court has now officially declined to answer that question directly. Now, you could argue they've already implicitly answered it in cases like Heller and Bruin, which discussed the right to purchase firearms. But having explicit Supreme Court precedent stating that acquisition is protected would have been incredibly valuable for future litigation. The Perez case dealing with interstate travel was also important. It challenged Massachusetts's licensing regime that gives law enforcement discretionary power to deny non-resident travelers temporary firearms licenses. This affects anyone who travels across state lines with firearms and wants to exercise their Second Amendment rights while traveling. But the court has declined to hear that case as well. So those are our 2 denials. Now let's talk about the big 3 cases everyone has been watching. Duncan versus Bonta, the California magazine ban case, Gator custom guns versus Washington, the Washington state magazine ban case, and Vimont versus Cook County, the Illinois rifle ban case. Here's what happened. These 3 cases were not on this morning's orders list at all. They weren't granted, they weren't denied, they weren't GVR'd. They just weren't there. Then at about 9 a.m. Pacific time, all 3 cases got rescheduled for conference this Friday, January 16th. Let me give you the score count here. This will now be the 5th conference for Duncan, the 4th conference for both Vimont and Gator. These cases have been sitting at the Supreme Court for months, getting conferenced over and over without any decision. Now, this is both good news and bad news. Let me explain the good news first. None of these cases were outright denied. That would have been the worst possible outcome, essentially leaving unconstitutional laws in place and signaling to states that they can continue ignoring the Second Amendment. None of the cases were GVR'd either, which stands for grant, vacate, and remand. A GVR usually means the court thinks the lower court needs to reconsider in light of some other recent decision. The fact that all 3 cases are still alive means hope still exists. The Supreme Court could grant cert to 1, 2, or all 3 of these cases. They're still considering them, which is better than an outright denial. Now here's the bad news. It's been months, and the Supreme Court still doesn't know what it wants to do with these cases. This feels eerily similar to what happened last term with Snope versus Brown and Ocean State Tactical versus Rhode Island. Both of those cases got conferenced repeatedly throughout the term, keeping everyone's hopes up, only to be denied at the very end of the term. I really hope that's not what's happening here. These cases are too important. Duncan challenges California's ban on standard capacity magazines. Millions of Californians own magazines that hold more than 10 rounds. If the court denies cert in Duncan, tens of thousands of law-abiding citizens could become criminals overnight when their grace period expires. Gator challenges Washington's similar magazine ban, And Vimont challenges Cook County, Illinois' ban on so-called assault weapons, which are really just common semi-automatic rifles like the AR-15. These cases affect millions of Americans living in states with restrictive gun laws. Now, here's something interesting that just happened. A huge new case has been added to the Supreme Court's conference schedule. NAGR versus Lamont, which is a case out of Connecticut that was petitioned to the court back in October 2025, has finally gotten its first conference date scheduled for January 23rd. This is massive because this lawsuit challenges both rifle bans and magazine bans simultaneously. Let me read you the question presented. Whether a ban on the possession of AR-15-style rifles and firearm magazines with a capacity in excess of 10 rounds, both of which are possessed by millions of law-abiding Americans for lawful purposes, violates the Second Amendment. If the Supreme Court takes NAGR versus Lamont, it could potentially end both rifle bans and magazine bans nationwide with a single decision. That would be huge. Here's my guess about what might be happening, and this is pure speculation on my part. I think the Supreme Court might reschedule Duncan, Gator, and Vimont again this Friday so that they all end up on the same conference schedule as NAGR versus Lamont on January 23rd. That would put 4 major Second Amendment cases on the schedule for the same conference day. We'd have 2 magazine ban cases from California and Washington, 1 rifle ban case from Illinois, and 1 case challenging both rifle and magazine bans from Connecticut. That's both terrifying and exciting. The Supreme Court might be trying to get all their ducks in a row so they can decide which case or cases to take that would provide the clearest vehicle for ruling on these issues. They might want to consolidate similar cases or choose the one with the cleanest facts and strongest record. Magazine capacity bans affect at least 9 states: California, Colorado, Connecticut, Hawaii, Maryland, Massachusetts, New Jersey, New York, and Washington. Rifle bans affect at least 7 states: California, Connecticut, Hawaii, Illinois, Maryland, Massachusetts, and New Jersey. Some jurisdictions like Cook County and various cities have their own local bans as well. A Supreme Court decision on either issue would have massive nationwide implications. We know from Bruin that at least 6 justices are serious about enforcing the Second Amendment using the text, history, and tradition test. We know that standard capacity magazines and common semi-automatic rifles were protected at the founding and have been in common use for lawful purposes for decades. The historical record strongly supports striking down both types of bans. There's no founding era or 19th century analog for banning common arms or limiting magazine capacity. The few arms restrictions that existed historically dealt with dangerous individuals or sensitive locations, not blanket bans on what average citizens could own. So the legal case for these challenges is strong. The question is whether the Supreme Court will take them up this term or continue kicking the can down the road. The continued rescheduling is frustrating. Every week these cases get delayed is another week that millions of Americans are denied their constitutional rights. Every conference that passes without a grant is another opportunity for the court to let unconstitutional laws stand. But we can't give up hope. The fact that these cases are still alive matters. The court could grant cert at any time. One Friday morning, we could wake up to the news that the Supreme Court has agreed to hear Duncan, or Vimont, or NAGR, or all of them. That's why it's crucial to stay engaged and informed. Make sure you're subscribed with notifications turned on. I'll be monitoring the orders lists every Monday and bringing you immediate updates when anything happens. If the court grants cert in any of these cases, you'll want to know right away. I'm also planning to attend the Attorneys on Retainer Conference on February 20th and 21st. It's going to be a great opportunity to meet face-to-face with self-defense experts, attorneys, and fellow Second Amendment advocates. My friends from Guns and Gadgets and Heavy Duty Country will be there too. Check the description box for more information if you're interested in joining us. In the meantime, all we can do is wait and hope. Hope that the Supreme Court is taking its time because they want to get this right. Hope that they're lining up multiple cases so they can provide comprehensive guidance. Hope that they'll ultimately do their job and protect our constitutional rights. This Friday, January 16th, will be another big conference day. We'll find out if Duncan, Gator, and Vimont get granted, denied, or rescheduled yet again. I'll have a video up as soon as the orders list drops Monday morning. Stay strong, stay informed, and never give up on your rights. These cases matter. The outcomes will affect millions of Americans for generations. We need to keep pressure on the courts to follow the Constitution. Thanks for watching, and I'll see you in the next update.